Now, former President Jacob Zuma is facing 16 charges of corruption, money laundering and racketeering relating to 783 payments allegedly made to him linked to the arms deal, while his co-accused French arms company Thales is accused of agreeing to pay 500,000 rand. The company and the former president are expected to make an appearance in the Pietermaritzburg High Court after more than 10 years of delays and legal wrangling. To explain further what these charges are and the court proceedings that are due to unfold today, I'm joined by attorney Mpumelelo Zikalala of Zikalala Attorneys. A very good morning to you and thank you for your time. We're hearing of a lot of legal jargon this morning, words like a pre-trial that's set to resume today, and of course many saying that it's not the actual trial but a pre-trial. Just talk us through the components of a pre-trial, what it means and how exactly it works.
Basically, a pre-trial is a session where both parties are there to present their state of readiness to the court. You will have certainly look at the number of witnesses that you have, confirm whether all the documents that need to be exchanged between the two parties have been done. Also look at the availability of the legal representatives that are going to be involved in the matter, and also the availability of the court of saying, do we have enough presiding officers on the time that you want so that you'll be able to hear the matter. So it's basically to make sure that when we start the trial, we start the trial on an agreed date and there are no delays. You must remember that this is done in compliance with the Constitution. Under the Constitution, I think it's section 35(3)(d). It says that the trial of any accused person must start and complete within a reasonable amount of time, within the shortest amount of time. So to ensure that there are no disturbances, we hold this pre-trial so that everyone is clear, everyone is on the same page, and when the date to start the trial is actually set, everyone is ready to present their evidence.
Now, as you speak about delays, we know that former President Jacob Zuma's lawyers are speaking of wanting this matter to resume in October, and on the other end, we're hearing of the NPA that's speaking about the year 2021. How difficult is it for the NPA to go ahead with this prosecution, and perhaps what are the broader challenges that come with this delay?
Certainly, they would have to present their arguments to the court and state the reasons why. And the court will interrogate whether those reasons are sufficient enough. Is there someone to blame? Is it purely because of the lack of professionalism on the side of the NPA? Or is it due to circumstances that were beyond their control? If it's something that they could not control, however, it is vital and crucial in this matter, then certainly the court may grant them the indulgence and say, okay, let's start on this date. So, but there are a number of factors that are linked to the actual trial date or to the date where the actual trial is going to start. Another important factor is this. There have been a number of averments that have been made by the NPA in various platforms during the process where the matter was moving from the KwaZulu-Natal High Court all the way to the Supreme Court of Appeals, stating time and again that they are ready. So they would need to provide compelling reasons to the court to state, why have you changed your stance? Did you discover new evidence? Is it easy to discover those evidence? However, there must also be cognizance that the quality and the quantity of the evidence is also going to be impacted due to the passage of time. So they have to be aware that further delays to this matter may actually prejudice them instead of making their case stronger.
We also learn of the state wanting an indictment amended. What exactly does this mean, and in what instances can this be done?
Amending the indictment simply means that you want to add more charges or want to remove more charges. That can be done up until the stage where the accused actually pleads. Now, is to basically say, at the time we did the investigation as the South African Police Service or while we're preparing as the NPA, we then discovered new charges that you want to give to the accused, but we want to add them. Now, the question would be, the addition of those charges, does it require more preparation from the side of the accused, in this case the former President Jacob Zuma, or does the evidence that they already have in their possession, the witnesses that are going to prove his innocence, are they sufficient to deal with the additional new charges? So it would highly depend on the nature of those new charges, whether they would need more time to prepare or they would say, we are ready to proceed on the date that is going to be agreed upon. But certainly with the changing or the amendment of the indictment, it can actually happen at any time up until the accused has actually pleaded.
And as the former president and co-accused Talis head to the Pietermaritzburg court today, in terms of assessing the entire case, what are the very evident loopholes that come with it?
The first one is the passage of time. We must remember this happened over a number of years ago. The availability of witnesses that are going to give viva voce evidence may be limited. Some of them maybe have gone to other countries. Some of them have even passed on. So the availability of evidence is going to be very crucial. Another process is that the availability of documentary evidence where you can follow the network of the money, because at the end of the day, it all has to do who was paid, what amount, at what time, and to which account. So if you can't prove that, it's going to be a problem. Another burden which is on the side of the NPA is that when it comes to criminal matters, you have to prove your matters beyond reasonable doubt, meaning there must be no other explanation available other than the explanation that has been brought by the NPA. So if the evidence that they have, due to the quality and the quantity of that evidence, is not able to prove such, then it basically means that the court will be forced or must actually give a not guilty verdict.
The former president is facing 16 charges here of corruption, money laundering and racketeering. Exactly where do these charges stem from as we try and assess the number of payments that were allegedly made in connection to the arms deal?
That they basically come from an allegation of saying that while he was in government, he facilitated a sort of a protection type of deal of saying that I will protect you from further investigations, I'll protect you from further probing if you give me an amount of 500,000 rands per month. Those are allegations, if I may add. Now, the state will have to prove that that actually is true. There's actually a flow of money from the arms company into the accounts that are directly linked to the former president. If they can't do that, then they can't prove the charges that they've placed before the former president.
Now, as you speak about the loopholes that are in place as we assess this case, we also know that, you mentioned the number of years that have gone by and the witnesses some of them who may have passed on, like Bredenkamp, who was a key factor in this case. As you assess the case and the strength of the case for the former president, exactly how strong of a case does he have against the state?
I must mention that from all proceedings that have taken place, we have not really seen any forms that the evidence is going to be used by the NPA, so it might be difficult to assess. However, if you look at the fact that the charges have been withdrawn before, there must have been a reason of withdrawing those charges, whether it's political or non-political. However, there must have been substantive enough to say that even though there are allegations that do exist, if they do, however, they're not going to be enough to be proved in a court of law. Now, that is the crux or the most important part. Are they enough to deliver a guilty verdict? Are they enough to make sure that the person, it can be shown that the former president is guilty beyond reasonable doubt? If they are not, then certainly this process will be a waste of time, and there's no guilty verdict that will be obtained from these proceedings.
Thank you so much for your time there. Mpumelelo Zikalala of Zikalala Attorneys, just giving us a sense of the case that's set to resume in the Pietermaritzburg High Court today. Former President Jacob Zuma, as well as co-accused Talis.